So my name is Kaloki and I am a husband, a father. I also have a background in telecommunications engineering. I currently work in business analytics and data science. But for this segment today, the conversation we're having about occupational health and safety, I'll be coming from the point of view of a multicultural safety ambassador. I'd like, first of all, to acknowledge the traditional owners and custodians of the land upon which we are operating today. I'd like to pay my respects to their elders, past, present, and future. I'd also like to say that the sovereignty was never ceded. Now, Multicultural Safety Ambassador Program is a program that was put together through Migrant Worker Center and basically aims at delivering community legal education on occupational health and safety matters for migrant workers to be safe in their day-to-day activities in their workplace. It's important to preface the conversation by saying that today's information is general in nature, and it's not legal advice, rather it's legal information about health and safety matters. A migrant worker is anyone, somebody that's born overseas and they arrived in Australia and they conduct work-related activities regardless of their visa status. And to answer that question, probably I'll share a little story. So Wanjiko came to Australia 12 years ago, and as an international student from Kenya. And she worked part-time and studied. She struggled a bit, you know how it is, and managed to finish her course, complete her degree, and transition through permanent residency, and now she's a citizen. And she recently bought a house, so a success story. And so currently she works at the university, but she is very economically driven, so she also does part-time work in aged care and disability, and also drives Uber sometimes. And so she sustained a back injury, and so she has been having back pains and recently dislocated her left shoulder while attending a client in one of her jobs, part-time jobs, and thus is unable to work until her doctor declares her fit for work. So if Wanjiko was having this situation back in her home country, Kenya, what do you think would have happened? And that's something about, would she be compensated, or would there be a framework to actually help her? But since she is in Australia, then there would be a framework within the work health and safety and within the legal framework that we have that can assist her to navigate that situation. So in that story, Wanjiko is an example of a migrant worker. And for anyone who's been able to arrive into Australia through maybe coming as a student or any other means, say like professional or work visa, etc. Whoever conducts any work or part-time, cash in hand, gig economy, Uber, delivering, all those are considered as migrant workers. There are two parts to this question. What counts as an injury and what counts as the injury having occurred in the workplace? And an injury is considered to mean a mental or physical. It could be, in the general sense of things, it could be also a disease or condition or ailment, or an aggravation of a pre-existing disease or injury. Now, it is considered to have occurred in the workplace if it arose out of the course of employment. And this means that the injury may have been considered by the nature of employment such as maybe through a task that was being done, maybe through equipment, surroundings, the environment. It could also have occurred during a time that the employee was working, but maybe not as a result of the nature of work that they were doing itself. Maybe it's an incident or an accident. And with this definition, more information and the different forms or shapes of injuries and what they could result to can be found in the information that we'll share through WorkSafe as well. But let's take the case of Angela, an international student from Colombia, and she works as a cleaner in a construction site. And her boss told her to prepare cleaning chemicals, but she's never been trained on how to handle those chemicals. So even though she needs to do the job, it's the role of the employer to train her and make sure that she's equipped with the skills and the knowledge to be safe. So from this story, did Angela know her rights? Maybe not. Maybe was she scared to say that, I don't know how to handle these chemicals? Or she was maybe, when you come in and you really need that dollar, that fast earning, it's really essential, it's critical, and you need it. And you don't want to say no to the job, and you kind of, in a tight place. So Angela got a chemical burn in her hand. But if we look at that story and say, okay, what's the role of Angela's employer in this scenario? We can say that the employer, even though they have many duties, but the most important one under the Occupational Health and Safety Act, Section 21, it says that the employer must, so far as is reasonably practicable, provide and maintain for employees of the employer a working environment that is safe and that is without risks to health. So that's the main role of an employer from the Act, from a legal standpoint. There are other specific duties which go into maybe providing training, monitoring the health of employees. For example, with the COVID-19 situation that we have at hand now, the role of the employer includes just scanning or just making sure that they know who's coming to work that day. Are they safe? Do they have, just monitoring the overall health situation with employees. That's a great question. Now, the employee has rights and obligations, which we need to mention, which stem into their responsibilities. So, for example, under the Section 25 of the Act, number one, it is essential for the employees to take reasonable care of their own health and safety. Secondly, they need to take reasonable care for the health and safety of others who may be affected by their acts or omissions. Thirdly, they need to cooperate with anything the employer does or requires in order to comply with occupational health and safety requirements. And lastly, but not least, the employee should not intentionally or recklessly interfere with or misuse anything provided at the workplace for occupational health and safety. So, looking at Angela's story, her being an international student, she's new and she hadn't been trained. Part of an employee's rights is to say no to unsafe work. So Angela could have said to her boss, no, I'm not trained to do this and this looks unsafe to me and I'm not comfortable doing this. And within the act, you won't get fired or get dismissal from your job because you said no to unsafe work. So in the event that an employee has been asked to do a task and maybe they're not familiar with the equipment or the process or something in that process is not clear, they have the right to go to their employer and say, excuse me, I'd really like to do this, and I really like to make a difference in my job here, but I am not sure about this and this and this aspect of the job, and if I could get some assistance or some training, that would be great. So if you're injured at work, you may be entitled to time off and compensation. Now, all workers are covered by the employer's insurance or by WorkCover. And you can get paid time off to recover, medical costs can be covered, and even financial compensation. The most important thing, I guess, in this is to understand that being healthy is more suitable for sustaining a quality of lifestyle in the long run. So I guess that getting to the point where an injury has occurred should be the last thing that we want. We want to be safe and healthy. Now, in case somebody gets injured, there is a flow chart that requires somebody needs to understand step by step what they need to do, and it will be shared. But the first thing is, if I look at that flow chart, the first thing that we need to understand is the most essential bit is seeking medical help if it is needed. Strongly recommend contacting an organization that can help as soon as possible, which means probably your union or Migrant Worker Center, Union Assist. And secondly, we need to have an incident report written. If there's no official incident report available, like a form, just write down what happened and provide a copy of what you've written down to your employer. That will suffice as an incident report. The next step would be, do you need time off work because of the injury? If it's yes, then you get a certificate of capacity from your general practitioner, your GP. If no, you can submit a worker's injury claim form to your employer within 30 days. It is critical that we understand it has a time expiry. It needs to be within 30 days. The next step would be your employer's insurance has 28 days to accept or reject a claim. If you're asked to see an independent medical examiner, then yes, a worker must attend that examination. If you're not asked to attend, that's okay. However, if you're asked to see an investigator, then a worker can and should refuse. And if that is not required, then that's okay. The claim gets accepted or not accepted. So let's say the claim got accepted, then it's a successful outcome. Monitor your payments and return to a work plan, and then get help if there are any other issues coming out of that. If the claim is not accepted, then the worker can dispute the decision, and most importantly, needs to get help immediately. So in the form of legal advice. Yeah, that's a general flow of an injury claim process. It depends. See, WorkCover cases are very specific, and the details are, number one, confidential to the case, and also it could have different answers depending on the scenario. If a situation like that occurs and somebody is not sure of what the outcome is going to be, or in the future, would I maybe not get employment because I launched injury claim, that should not be an issue. In fact, I think best to check with your union or with the Migrant Worker Center or Union Assist about the specifics of the particular case. Yeah. So it has to be case by case within the legal framework obviously confidentiality, etc. But check with, get legal advice as soon as you can. In each workplace, there would be a health safety representative, and the first point of contact if a worker is not sure of a situation would be their health and safety representative. If you don't have one in your workplace, you can elect as health and safety representative. In fact, I recently got nominated and elected in my working group as a health and safety representative, and went in for training. And so if there's a case, anybody in my work group can approach me and we can have that conversation, and we can take it to the health and safety committee, which is which oversees the discussion between the workers' concerns and the management. That would be the first point of call. From that, for example, in Angela's story, she reached out to her union, and her union assisted her to launch a work injury claim for the chemical burn on her hand because of the work she did. But if a situation is unclear, health and safety rep, union, Migrant Worker Center. If you just go online and Google Migrant Worker Center, they'll be assisting. If your claim is rejected, as soon as you can, seek legal advice, legal help. Go to your union as soon as you can if you hadn't already involved your union. Best practice, when you're going into launching an injury claim, get your union on board so they can guide you every step of the way. And in case your employer or the process goes sideways or not, it's something that you didn't expect happens, then you have your union on standby to assist. Which means actually it's important that in your workplace you do the union subscription. Yeah, that will be helpful. Generally speaking, regardless of whether an incident in your workplace results in injury or not, it needs to be reported. So if it's a near miss or a hazard, something happened, somebody slipped, they didn't break anything, grateful that happened and nobody got hurt, but that needs to be reported as an incident. Date, place, what happened, even if it's a near miss. Why? Because in the future, if that's not fixed and then it results into another incident where maybe somebody gets injured, then it could be that it develops the context of, hey, we've had this reported, but nothing was done, and now somebody got injured. So it's important to have those incidents reports going through. Yeah. So in terms of returning to work after an incident or an injury, it could be that you go back to the same employer, and they will provide duties that are maybe lighter duties that would allow you to work and maintain maybe your quality of lifestyle or your income. Now, your employer has the duty to provide tasks that you're able to deliver upon, and that return to work formula, it's something that you need to work out with your employer, and also probably if there are any issues, get in touch with your health and safety rep and probably your union to assist with that, the specifics on the legalities of what's happening in your situation. When we talk about legal advice and support systems, there are legal services, community legal services that are free, and if you have access to internet, you look at, for example, Migrant Worker Center. On their website, you find a lot of resources. WorkSafe. We have unions. We have Fair Work. So all those organizations are there to assist with occupational health and safety related issues. And then for people that may have a language barrier or things like that, there are in-language translations on the Migrant Worker Center for information that will assist them and point them in the right direction. As well as their regular duties, during COVID-19, your employer must ensure appropriate distancing in alignment, with the state regulations and the framework that's in place. And that's for everyone: customers, contractors, employees, suppliers, and other workers. Also, the employer should provide adequate sanitation, hand washing facilities, encourage workers to wash their hands and practice proper personal hygiene, and also monitor the health of employees, also while ensuring that the surfaces or touch points are sanitized and clean. And if you're working from home due to COVID and your work allows you to have that option, your home desk becomes a workplace. And so you would need to ensure that, for example, working with your employer, you have equipment that's suitable to support your work. For example, desk setup, chair, monitors, keyboards, etc. And if the environment is also conducive, noise, lighting, children, housemates, etc. How about fatigue? So sometimes you need to have proper breaks and a reasonable workload, considering that you're working from home. But all these things need to be discussed and closely work with your health and safety rep. Again, if you don't have one, you could elect one. There's a process. If you're not sure how to, Migrant Worker Center have resources to assist you, elect HSR in your workplace for representation. Some other issues are around mental health due to isolation and having lack of access or support to your team or to your manager. And those are issues that, if you feel that you need that support, just reach out to either your HSR or your manager. Just raise those issues. It's not something that somebody will get penalized for from a work health and safety point of view if you raise a concern that you're experiencing burnout or isolation, or you're having reduced opportunities to socialize or relate with your workmates.